Good evening. My name is Nicholas Miller, and I'm a professor both at Andrews University and here at Washington Adventist University. And I'm delighted to be able to introduce this special program this evening at the Honors College, sponsored by both the Center for Law and Public Policy here at WAU, as well as Liberty Magazine. And my co-host this evening is Bettina Krause, who is the editor of Liberty Magazine, and we're joining together to put on a special program, a post-Supreme Court argument analysis of the arguments that took place today in the case of Groff versus DeJoy, which has to do with Sabbatarian accommodation in the workplace, something that Seventh-day Adventists have a great deal of interest in. I'm going to allow my co-host, Bettina Krause, to introduce herself and say something about Liberty Magazine, and then I will introduce the program in a more formal way.
Thank
Bettina?
you, Nick. It is a delight to be here today. The first, I hope, of many collaborations between Liberty Magazine and the Washington Adventist University Honors College. Many of you may already be familiar with Liberty Magazine. In fact, how many of you here have heard of Liberty Magazine? Yeah. But for those of you, especially those watching online, who may not be familiar with Liberty Magazine, this is a journal with a very interesting history. It was first published in 1906, and it is still going strong today. So that means for almost 120 years, Liberty Magazine has been bringing a distinctly Seventh-day Adventist voice to issues of church-state relations and religious freedom. And it's fascinating, Nick, when you look at the archives of Liberty Magazine, because really for more than a century, we have had a front seat to all the major religious freedom issues that have come up in American society in law or culture, and we have not only reported on them, but provided analysis for them. In fact, in preparation for this evening, I went back to Liberty's archives to look at how we covered the case from 1977, which brings us all here today, TWA versus Hardison. And sure enough, there in the September issue of Liberty Magazine, we have an article. And it is fascinating to see that author grappling with the question, without the benefit of the hindsight that we have today, the question of how this opinion is going to be applied in the lower courts and how it is going to affect workplace accommodation. And he considers all the, parade of horribles that have been bandied about, and, the dissent of Justice Marshall, who said, Hardison will strike a fatal blow to workplace accommodation. But our intrepid Liberty author was not convinced. And he hazarded the opinion that Hardison would probably not have such catastrophic effect for religious believers.
Wishful thinking, I'm afraid.
Well, let's just say it was not Liberty Magazine's most prophetic moment. Let's just leave it at that, shall we? Because, very soon, of course, it became clear to everyone that this ruling was a problem. And that's why we're here this evening, right, Nick?
That's right. And let me just briefly introduce the topic, and then both Bettina and I will introduce our special guests who are going to guide us through the thickets of it. I'm glad you mentioned when Liberty Magazine was first published, 1906. Much has changed in our country. Probably in 1906, the biggest threats to religious freedom were still from the government power, and certainly at the founding of the American nation, power was seen as held by the government, and the greatest threats to your civil liberties came from the government. Well, since the 1900s, the growth of American capitalism and industry and corporatism means that we interact much more often with corporate America in the form of either being customers or employees than we do with the government. And, come the 1960s and 70s, and Congress realized it's not enough to protect your civil liberties and equalities from the government if private industries and enterprise and business can treat you as they will. And so that's what happened in the 1960s and early 70s. Title VII is the statute which causes private industry to respect your race, gender, and then ultimately religion as well. And so that was the backdrop to the case of Hardison in 1977, where the court had to interpret the question of undue hardship. You see, religious freedom isn't an absolute right, either against the government or against private industry. You can't have people stealing, rioting, or killing in the name of religion. There have to be boundaries. And even in the workplace, you can't have somebody assert their religious practice in a way that's going to destroy your business. But what the statute said was that if the employer could accommodate your religious practice without undue hardship, then it must do so. The court in 1977, in the case of TWA versus Hardison that Bettina alluded to earlier, the court there decided that undue hardship meant anything more than a de minimis burden on business practices. Now think about that for a moment. De minimis is what it sounds like, right? Something that's very little. And so in the case of TWA versus Hardison, the court decided that a union seniority agreement to alter that would be too great a burden. And therefore the Sabbath-keeping employee lost that case. The court also talked about a raise in pay, having to pay premium pay would be more than de minimis. And therefore, from that point forward, religious liberty became, and I'm not going to say red-headed stepchild, I'll just say disfavored.
Says the redhead.
Yes.
Became the disfavored right in the business environment. If you were an ethnic minority, if you were a woman, if you were handicapped, you would have a higher level of protection than you would if you had religious convictions, which is kind of a funny place to be for a nation that's First Amendment was focused on religious freedom. So we have been struggling with that standard for the last 4 or 5 decades, trying legislation, trying litigation to get the court to revisit this standard. And we believe, we hope, we pray that lightning has finally struck, and we have a case coming out of, well, with an attorney from California, Alan Reinach, who's next to me, handled the case at the trial court level, bringing suit. And I'm going to be interviewing Alan about the first stages of the case. And then Hiram Sasser, next to Alan here, with First Liberty, has been part of the appellate team. And what I'm going to do now is briefly, well, Bettina's going to introduce Hiram, and I'm going to introduce Alan, and then we'll start the interview. So go ahead, Bettina, and tell us about Hiram.
So I'm delighted that we have with us today Hiram Sasser, who is Executive General Counsel for First Liberty Institute. He oversees First Liberty's litigation and media efforts, and his practice focuses primarily on First Amendment and other constitutional and civil rights issues. Now, for those of you who've never heard of First Liberty, this is a powerhouse. It is the largest legal organization in the nation that's dedicated exclusively to defending religious liberty for all Americans. And so Attorney Sasser here is part of a team of legal experts who have helped First Liberty achieve something which is quite extraordinary, and that is a win rate of 90% across all legal matters. And all I can say is that is a very good omen for our case today. At least I hope it is. But
we're highly selective of what cases we take.
No, you're very astute as to what cases you take. But welcome, we're glad you're here.
He is very astute, for sure.
And next to Hiram is Alan Reinach, who I can introduce as a good and old friend. Not that he's old, but our friendship is old.
Oh, I'm old.
Going back to New York City when I was a law student there in the city, and he was a recent law graduate. We attended the same church in Upper Manhattan. He moved to the West Coast where I'd been from and has been the executive director and general counsel of the Church State Council, since 1994, almost 30 years, where he is the Parle Director, Public Affairs and Religious Liberty Director for the Lake Union.
For the Pacific.
I'm sorry.
You were in
I
the
just
Lake
came
Union.
from the Lake Union. Pacific Union of Seventh-day Adventists. He's recognized nationally for his expertise in religious employment discrimination matters, having litigated cases for those 3 decades. He has litigated cases in the 2nd, 3rd, 9th, 10th, and 11th Circuit Court of Appeals, and is now assisted with a Supreme Court case, and has written a number of amicus briefs for the Supreme Court, including one for the case that Bettina and I were involved with back in the early 2000s. Alan also serves as co-chair of the American Bar Association's Religious Liberty Committee, and writes frequently on church-state issues, including for Liberty Magazine.
Thank you for adding that.
Yes. So, Bettina, go ahead and
Sure.
speak to Alan about the case below.
Sure. So we need to set the scene, Alan, for everyone who's watching and those
Sure.
here who may not be as familiar with the case as you are. I've heard you describe this case as a David and Goliath case. So take us back to the very beginning. How did this case come into your orbit, and where did it go?
Well, so Gerald Groff was working as a rural route carrier in Lancaster County, Pennsylvania. And when he started work for the post office, he'd come back from doing mission stints in different parts of the world, very devout Christian. And of course, for decades, the post office didn't deliver anything on Sundays. And Sunday, he observes as the Lord's Day and does not work. But you may be aware, you may have received Amazon packages on Sunday. The Amazon contract caught up with him. And pretty quickly, when he got into trouble, he reached out. He just started looking for another job, but somebody astutely suggested, well, I don't have a job for you, but I do have a lawyer. Reached out to a local Pennsylvania-based organization that contacted another national organization, Alliance Defending Freedom, and I had good relationships with them over the years because there aren't many attorneys that specialize, that are employment lawyers who do religion cases. We have a large national and regional association of employment lawyers that I've been very active in for many years, but you know, those who just do religion cases are practically non-existent. So they called me up and I'm like, post office? I've done tons of post office cases. I know a lot about the post office. And the fact that it was Pennsylvania was like, well, that's not a problem as long as we have local counsel. So we started working with Gerald, I think right about the time he first got issued a written discipline. And you know, we said, look, in the Postal Service, you have to file your EEO charge right from the get-go. You can't mess around. You just got to paper the thing over. And so we worked with him through all kinds of discipline until it finally got to the point where the next thing that was going to happen was he was going to get fired, and he didn't want to have a termination on his record from federal employment because that would preclude further federal employment somewhere else. So he resigned, and you know, we had the option of going to an administrative hearing before the EEOC, but with the post office and with the record that we had, you know, we made the strategic decision just to go into federal court.
So tell us about that record. I mean, what did you find in discovery
Well,
that really bolstered the case for Mr. Groff?
So, you know, looking at the facts, a couple of things. So he's at a larger post office in a town called Quarryville. They accommodate him the first holiday season through the Christmas season, but sometime in the spring, the postmaster there says, we're not going to do that again. This coming holiday season, you're going to work on Sunday. And so he finds a smaller post office at Holtwood that wasn't doing the Amazon contract. Now, the post office does seniority a little differently. It's not just your date of hire with the organization, it's your date of hire within the particular craft and office that you're in. So if you're a clerk and you go to be a mail carrier, you start from the bottom all over again. If you're at Quarryville and you go to Holtwood, you start all over again. He left his seniority, and you know, he's with the post office. These are jobs that once you get your foot in the door, and this is a part-time job initially, although they get a lot of hours, but there's no guarantee of hours. You know, what you're looking to do is move up and move up till you can qualify for a full-time job. And of course, the retirement benefits at the end of the day are very good when you're in government service. So he's setting himself back, you know, 1, 2, 3, who knows how many years by moving, setting himself back in terms of full-time job by moving to the Holtwood to avoid Sunday work. And while he's there, a funny thing happens. So as long as the postmaster, who's reasonably friendly to him, you know, knows when the Amazon contract catches up with him, he knows that Gerald is not going to work on Sunday, so as long as he can make the schedule and leave him off the schedule, he really doesn't have a problem covering the Sunday deliveries. But see, post office insists that everybody has to be treated exactly the same. And labor relations tells them, no, you can't do that. You have to keep them on the schedule just like everybody else. And the postmaster writes back and says, but it's working. We're getting the Sundays covered. There's no hardship by leaving him off of the schedule. That was a smoking gun when we got that email that basically admitted that we had a working accommodation and no hardship, right? So the hardship, such as it was when they had to put him on the schedule, and he'd call in Saturday morning, and Saturday morning the postmaster has to scramble to cover for the Sunday. And I think 3 times the postmaster himself had to cover. Well, they make a big deal out of that, but I know from my experience with the post office that postmasters are always having to cover, and in fact, because postmasters have to and are expected to cover for clerks and for mail carriers, they actually have rules about limiting how much they're allowed to cover. Why? Because they're taking shifts away potentially from those crafts.
And this is overtime often too.
Right?
Yeah.
So, you know, on the facts, no problem. We get into, one more point though, because we get into the legal process. And one of the things that you do is you take, when you have a large entity, you want to nail them down what their position is. And so there's a civil procedure where you ask them to designate the corporate representative who can give binding testimony for the company, or in this case, the agency. It's called a 30B6 deposition. So at this deposition, they bring forward the district director for the region that he's working in it. And the question is asked, when Groff was excused from working Sundays, did that cause any hardship on the post office? And the answer was no. So we take a break. We go in the next room. My co-counsel and I, we look at each other. We're like, we just got them on the record saying there was no hardship. Do we leave it alone? Do we go back in and mess things up, you know, by asking follow-up questions and give them a chance to maybe, you know, recover, right? So we say, no, we got it, right? They said no hardship, so we leave it alone. You'd think that the courts are supposed to take that seriously. It's their own rules, for crying out loud.
And this is my question, Alan, because you asked for summary judgment. It sounds like you had a great case. Why did the judge at the district court not agree with you?
Well, one answer would be providentially, the Lord knew we had to get this case to the Supreme Court.
Okay,
right?
let's keep that out of
Another
the mix.
answer would be that judges are not necessarily sympathetic to religious freedom cases. They tend to be, you know, very sympathetic to government agencies. I don't know that, you know, political persuasion played a role, but, you know, if you're, for one thing, you know, those of us who are people of faith, we think that religion is important. But if you're not a person of faith, you know, think about the history of religion. And if you really don't believe that there is, you know, an almighty God, then religion at its best is a relatively harmless myth, you know, the opiate of the masses, as Marx said. Or at worst, it has contributed to an awful lot of war and violence and mayhem.
Discrimination.
Discrimination. So, you know, if you really are very secular-minded, you don't value religious freedom the way some of us do. And we have had problems at times with judges. And I know Hiram's going to have his own experience of that as well.
Let me just sneak in one last question before Nick takes over with his interview. I mean, Mr. Groff has given his name to this case. For most of us, he's just a name, right, on a brief. Who is he? You spent a lot of time with him. Give us a sense of who he was as a person.
You know, Gerald is just a really solid guy. You know, he's a single guy. He's very devout. He's very gentle.
Wasn't he a missionary at some point?
Yes,
he told me he was
yes,
a missionary
he
overseas,
did
or
a number of years of mission service overseas.
what country do you know?
He doesn't like to say that.
Yeah, he doesn't like
I
to
see.
say.
So it could have been maybe an
Africa,
Muslim country
Asia,
or something.
that kind of area.
Yeah, but you know, he's just a really sincere Christian. I peg him as a bit of an introvert, you know, but just a really good.
What did he
guy.
do when he lost his job with the post office? What has he been doing since then, the litigation?
Well, he's now running the mailroom for a large retirement community, I think it is.
He can't get away from the mail.
You know, but
Kind of his thing. But the Lord has taken care of him, I think, is a point that should be made, right? You may not win the case immediately, you may lose your job, but you don't lose the protection of the Lord when you stand for your convictions.
well, but you know, there's plenty of stories of people who, okay, they lost their jobs and they got better jobs, but there's also plenty of stories of people who have really, really suffered.
Yeah.
You know.
Go
Fair
ahead, Nick.
point. Well, so now we come to the appeal, and that's where First Liberty came into the picture, I assume. We have Hiram Sasser, who I should also add in his introduction, teaches a First Amendment course at the University of Texas Law School in the state of Texas, and so has both a practitioner's background and an academic background. At what point did you get involved in the case? Can you tell us that story?
Well, Randy Wenger at the Independence Law Center and David Krause, who's a private lawyer in Pennsylvania, and Alan were doing the case together. And I've known Randy for a long time, and we've done a lot of different projects together. And kind of if you want to know who Randy Wenger is, if you know who Matthew Broderick is, Randy Wenger looks and acts and talks exactly like Matthew Broderick. All right. So in his younger years, I guess he was like Ferris Bueller, but I mean, seriously, you could like take him to a fancy restaurant, and you guys would be seated immediately. It's pretty funny. But anyway, he called me and he said, "We lost this case. This is really terrible. What do you think about it?" And I mean, to be fair, most of the time when Randy pitches me a case, I tell him it's really not a very good case, and let's not do that. That's how you get that 90% win rate. You can say no a lot, but he, he told me about the case, and I thought, this is a great case, because this issue of revisiting TWA versus Hardison and the de minimis standard. I mean, that's been on the deck. Somebody's got to go do that case. And there's a lot of cases that have attempted to address that issue that kind of came with a lot of culture war baggage in the case. Whereas, a Sabbath case, I mean, that's like an old school, straight out of your law books from like 1960 type of case. So it looked to me like a great case, a great vehicle. It had been handled really well at the district court. They had a great record of that admission that you were talking about. Just a lot of things that were really great about it. And the way we work at First Liberty is that we actually always bring in a private firm to partner with us on the case. And so that's when we brought in a law firm, Baker Botts, and so it was us and Baker Botts joining on for the appellate side, and so then we were sort of off and running and doing the appeal to the Third Circuit, and you know, to see what they had to say about it.
Okay, and what happened at the Third Circuit? What I guess we made good arguments there, but again, they didn't buy them. What did we argue and what didn't they buy?
Well, I mean, what they were constrained by, you know, what they thought was, you know, Supreme Court, precedent that they needed to follow. We made some arguments that, you know, that TWE versus Hardison was not necessarily of strong precedential value as to the statute, because it was really interpreting the guidelines that pre-existed, the EEOC guidelines on saying undue hardship that pre-existed the statute, the amendment to the statute that had undue hardship in it. So, as a result, you know, they felt somewhat bound. But even under the old rule, we lost 2-1, and so you know, that's a.
So you had one judge in your camp.
That's right, and it's always great to have a dissenting judge who writes, you know, basically
Helpful.
your advocacy piece for you.
Right.
That kind of helps you go see
Next step.
go what the next step is, and you know, you have your choice to go seek the Third Circuit review en banc, which is you ask. So on an appellate case, you have a 3-judge panel that gets assigned that does your appellate case. Okay, out of maybe, I don't know how many are on the Third Circuit off the top of my head, but I'm going to guess like 20, 22, 23 judges. You get a 3-judge panel, randomly selected. If you don't like the outcome of that, then you can go seek en banc review, which is all like 20-something or whatever of them sitting together, and go that route. But that really wasn't going to help us. Our problem wasn't there was conflicting precedent or whatever, or some issue at the Court of Appeals. The problem was the Supreme Court.
It was Hardison.
And
Right.
so we have a 2-1 split. So that seems like a pretty good vehicle. So let's go to the Supreme Court.
So let me just ask about the Third Circuit again for a moment in terms of what was the undue hardship that was what were they being asked to do that the court felt they shouldn't have to? I heard some talk about a memorandum of understanding.
Yeah, well, you had the memorandum of understanding about how they were going to select the people that were going to do these Sunday deliveries. It was not based on seniority.
It had to be an equal
It
allocation to everyone.
was just sort of anybody who was available who would do it, and then it went to people who were had not said they were willing to do it, and then cycle through those folks.
And so it was a memorandum of understanding between the postal and the union.
Yeah, between the post office and the union. And but it's not based on seniority, which is a separate issue,
Right.
that the statute, the Civil Rights Act, actually addresses. This was just sort of like how we're going to sort of randomly assign people for this particular duty.
So in effect, it was any agreement that the post office may have entered into with other employees or the employees as a whole is always going to trump or override.
Well, the Third Circuit didn't even really
convictions.
address the memorandum of understanding. That wasn't really the basis of it. They really grounded their decision on, well, there's going to be some other people that are going to have to fulfill the duty, and so that seems bad to us. And
Coworker
impact, and it really, I think, drove the Third Circuit's argument, and under the de minimis standard. And then Judge Hardiman, who was in dissent, basically pointed out that, look, I mean, you get these admission and everything else. Like, what? I don't know what's going on with these guys, but this is clearly an undue. This is not an undue hardship.
So coworker impact was talked about a bit in the Supreme Court, and I want to hear from Alan what was the impact? It does seem unfair, you know, we're going to remove the burden from the Sabbath keeper, but somebody else is going to bear his
And
burden.
don't forget Kagan's lovely hypothetical of
There's
the rural grocery store of 3 employees.
What was
Well, which
the
Title
actual-
VII doesn't
but-
apply to,
Right,
because it's
exactly.
less than 15 employees.
Exactly.
All right, but,
Yeah.
you know, I actually want to go back a step, because when you go to the district court, the jury is supposed to be the one to resolve fact disputes and decide what the facts are. The court is only supposed to rule in the case if the essential facts are undisputed. And here, it did certainly appear that at least the facts on hardship that the post office was putting forth were disputed. And so it was completely inappropriate
Well, what were they saying,
to
and what were
rule.
you saying?
Well, I mean, for example, the postmaster testifies that somebody quit because of this issue of Sunday. That is inadmissible hearsay evidence. But even today, we heard that thrown up in our face again. And it should never have been allowed in the first place.
Now, so our advocate, the advocate for the plaintiff, said there were 39 possible employees that could
Yeah.
cycle through that post. Is that accurate? I mean,
Yeah, let me explain how it basically worked, which was that for 46 out of the 52 weeks during the non-Christmas season, essentially, the way it worked for Sunday delivery is all the local post offices all basically chipped in people into the central annex in Lancaster, Pennsylvania. And then, and that would be around 40 or so.
Okay.
And they had plenty of people to cover, more than enough, that would arrive on a Sunday to cover all the shifts. And so to accommodate, Gerald really, would reduce the availability from 40 to 39, but they already had overage anyway, so everything would have been fine.
So it's the 6 weeks of the year.
It's just the 6 weeks. And okay, even if you take Justice Kagan's hypothetical, there's only 3 of them, okay?
Right.
What we're dealing with then is, if you want to do an equal distribution, is you're dealing with, at most, 2 Sundays. 2 Sundays for the post office. And they have the ability to go borrow or
From this
draw on
larger
from someone
group.
else. And what was fascinating, there are plenty of people who wanted the extra time because, frankly, they make more money.
Right, Sunday
And it's not
premium
like,
pay.
and the other thing too, they talked about all this premium pay, but really in this particular case, Gerald, he would work so many hours throughout the week that his Sunday delivery was going to be premium pay anyway.
Somebody was going to get premium pay for
I mean,
it.
it really was a wash in that regard. And then finally, one of the complaints that they had was, well, at some point the postmaster, as if the postmaster is some sort of grand lord, all right, who can't be asked to do anything but sit in a chair, all right, the postmaster had to deign to go actually deliver mail himself. Okay, well, if your hypothetical is the four person shop, all right, and so the postmaster gets paid a salary, you don't have to pay him any premium wages. You can actually save money on this one, all right, has to run a route on a particular day.
That's what he's there for.
Big deal.
I mean, it's totally disingenuous for them to make an issue out of that.
I mean, they acted like it was President Biden going to get out there in front and deliver the mail. It's a postmaster of a small postal office.
Right.
The post office is about half the size of this room.
I'm wondering if we can just step back a few steps, and I'm interested to know what you, Alan and Hiram, what surprised you, if anything, about the oral argument today and how the justices interacted with counsel?
Yeah, were there any
What was the
surprises?
most surprising thing for each of you?
I think for me, when it came to the questioning of our attorney, Aaron, we had prepared for all of the difficult hypotheticals that might arise. And they didn't ask them. What about folks who refused to get the COVID-19 vaccine because of their religious beliefs. And doesn't that raise issues of public health and safety that, would arise to an undue hardship? Or what about issues where religious freedom impacts with civil rights and, use of pronouns, or, some of the kind of conflicts with gay rights? None of those questions arose. When it came to the questioning of the Solicitor General, I really think that they kind of let her off the hook in the questioning about just really how she somehow reconciled that you could have a partisan test without the de minimis language.
I don't, it was like, the argument that the government was advancing was this: we know you guys are not going to want to go with de minimis anymore because it doesn't make any sense with the statute, and it's obviously wrong. So let's call it substantial expense.
Substantial cost or expense.
Yeah, and let's call it that, but then have it mean exactly the same thing as de minimis, have a nice day. And oh, by the way, plaintiffs sometimes do okay and survive summary judgment. Here's 4 examples, as if that was like this really great sampling pool of success.
Not getting your case thrown out is to them a win.
Like 4 examples,
Right.
or maybe they had 5. I guess I should say they had.
It was 5.
They had 5.
4 of them were Adventist cases. Mine and Todd McFarlane's.
So the thing that surprised me was I was pleasantly surprised to find out that Justice Sotomayor was very concerned that corporations, bottom line, that their profit margin would be negatively impacted, and she was concerned about that. And concerned about burdensome government regulations of business. And concerned about the cost impact of compliance with civil rights statutes by corporate America. So all that sympathy,
sarcasm.
all that sympathy for big business was surprising.
Refreshing even.
And I wouldn't have predicted that.
So let me ask you this. So there were 2, just to summarize briefly, everyone agreed, including all the justices in both parties, that de minimis was not the proper standard, but and that should be set aside, de minimis.
I don't know that Elena Kagan agreed that it should be set aside.
Well,
she was making a big point about stare decisis is precisely for cases where we get it wrong.
So, which was a really, in fact, I wanted to ask about that. I thought stare decisis was for interpretations of ambiguous or uncertain statutes, and it wasn't meant to protect just plain wrongness, but...
I'll let Hiram address that.
I mean, she basically said if it was right, no one would want to overturn it. So only if it's obviously wrong do we save it through this artificial construct called, statutory stare decisis, and I found that to be quite fascinating.
Well, I find it highly implausible. I mean, stare decisis is really meant to preserve the stability of the law through allowing plausible interpretations of ambiguous or a range of meanings to be.
Well, it's very consistent. Plaintiffs lose. That's highly workable, and it's very consistent. I don't know what the problem here is.
What's the problem? So,
well, except for the five examples, and then that was you didn't lose, but you didn't win necessarily.
Right.
So, but
we won the right to go to trial.
So it's not too bad.
So these were the 2 standards that were being pressed. The government was suggesting de minimis really means substantial cost or expense. They wanted to acknowledge this. Where maybe we shouldn't say this de minimis language, but we should say substantial cost or expense, which has really been the standard for the last 40 years. Plaintiffs are saying no, we want significant difficulty or expense. Can you explain the difference between significant difficulty or expense versus
Sure.
substantial cost or expense? Is it a meaningful difference?
This is not a game of semantics.
All right.
What this is substituting one phrase for another, for the de minimis phrase, and keeping a body of law that basically gives corporations virtually a get-out-of-court-free card when it comes to religious accommodation. Keeping in place a standard that you had all the major faith groups filing amicus briefs saying, we are suffering, we are hurting, please help us. And on the other side, you have the Solicitor General saying, everything's coming up roses, everything's great. And it doesn't seem plausible that the court is going to buy, this rosy picture as against all of the faith groups just screaming for help.
So, Alan, that really struck me as well, and I actually noted down the Solicitor General's words when she was being pressed by Justice Alito on this issue. And she said that the way the EEOC and the lower courts have interpreted undue hardship has provided, and I quote, a substantial zone of protection for religious freedom. And I thought at that moment, I bet Alan's fighting the urge to jump from his seat.
Well, and our listeners should know that that Seventh-day Adventists got a shout-out just at this point. It was Justice Alito who pointed to the big stack of amicus briefs, one of which my firm filed on behalf of the Seventh-day Adventist Church. Muslims, Jews, a whole range of religious groups.
Well, that was because the Solicitor General was saying all the minority faiths seem to be doing okay,
just fine.
And he holds up the briefs and he's like, well, they don't seem to agree.
And he mentioned the Orthodox Jews.
And he went through the whole list.
And the Seventh-day Adventists.
Right.
He said, so you're saying these groups have misunderstood?
That's right.
Yeah.
They're not in touch with reality.
It was actually a really nice moment.
Do you want to respond to the question about the difficulty
Well,
significant?
Well, one is robust and one.
Well, no, you did, yeah.
Go ahead.
Here's okay. As our co-counsel Aaron Street said, these words don't matter. What matters is what the actual application looks like. All right, you can use. It's not a magic word thing. The reason the significant difficulty or expense. The reason why we were advancing that test is because it is the definition for undue hardship in another statute that deals with employment, the Americans with Disabilities Act. And employers are used to applying it, and so it more mirrors what the undue hardship language of the statute is requiring of employers. And it would seem familiar. You could call it significant expense if you wanted to, as long as you applied it in a way that actually matched what an undue hardship is or is not. So what the Solicitor General wanted to do was basically say, we don't like de minimis, we'll call it something else that sounds better.
But still
But
apply
keep the
it.
case
We
law,
want to
yeah.
keep all the case law and keep all the precedent and keep all the regulations or the guidelines from the
Exactly
EOC
the same.
exactly the same. And it's like, well, I'm sorry, but if you have a really, really crappy food item, slapping a new label on it doesn't make it taste good.
Right, a rose is still a rose.
Can I raise an issue that was discussed?
Your illustration.
Yes, they're very picturesque.
Sorry.
No, there was a theme that came up quite a few times, and that was congressional inaction. It was
Stare
hard-
decisis.
Our failure to get a statute through Congress is now.
Right.
I
Used against us.
teased Richard Fulton, who's chaired our coalition in Congress for so many years, that if we lose, it's all your fault.
But let Bettina finish the question, because they're not going to
Let's
understand
set
the
the
point.
stage for the folk here and the people who are watching.
Yeah.
I mean, it was basically said that Congress knew about the 1977 case. They knew about Hardison. They knew about the difficulties that were allegedly created by that standard. Yet they chose not to act. And in fact, there was a piece of legislation, as you know, you just referred to, the Workplace Religious Freedom Act, which was introduced multiple times over more than a decade, and it did not pass. And so why then should...
2 decades.
Almost 2 decades, right. But so why then should the court grant what Congress has declined to give?
And that would seem to suggest, we say stare decisis like everyone knows what it means. Stare decisis is the doctrine that the court will give weight to decisions it has made in the past. It's not going to re-decide the same case every time. And the argument was made today that especially when it comes to statutes, see, the Constitution, Congress cannot change. So the Supreme Court is the only body that can change or reinterpret that. So it's more willing not to be bound by stare decisis, but when it comes to a statute, Congress could change it. So since Congress didn't change the statute in light of the court's interpretation, the argument is, the Solicitor General made and Kagan made, we should be bound by this stare decisis.
Right. And on the face of it, it sounds plausible, it sounds logical, but what say you?
Well, having been part of that effort for the duration, Congress, with all due respect, is completely dysfunctional. And their inability to get something done really says nothing about intent, as it were. It speaks volumes about its complete incompetence and the sort of divisiveness that has taken hold of our national politics. That's the reality. I mean, I can go into chapter and verse and why we had for a long time, the Republicans were far more concerned with business than with religion, so we didn't get very far, although we had sponsors at times like Rick Santorum.
Hillary Clinton?
Well, I'm saying on the Republican side. And the Democrats, of course, have been far more beholden to the gay rights interests than to, be sympathetic to religion. So for all that they're supposed to be pro-labor, the labor unions, Gerald's own labor union filed against him. So that shows you just how much support labor has for the individual rights of its workers, right? So the fact that minority religious interests can't get protected from the majority is exactly why we protect civil rights and constitutional rights.
The other thing that I found fascinating was, we basically challenged many reporters. Why don't you go find one of these disgruntled coworkers? Where are they? We can't find them. Well, ABC actually, they found some disgruntled postal workers. They happen to be retired from another state, but they found somebody.
Right.
And it's like, well, where's the people from Pennsylvania that were supposedly upset? Everybody Gerald talked to were very supportive. You wouldn't believe that if you listen to the Solicitor General argue, but I don't know that she necessarily felt bound by like the record and the facts.
She certainly didn't betray any being bound by it. I thought she played fast and loose with the record.
It was a little slippery.
Maybe Nick, we need to start wrapping up so we can go to questions.
Well, I was going to ask them to share, give us your prognostication.
Yes.
What do you think is going to happen? You can play prophets here in this Christian university.
And it's being recorded. So.
Well, I'll go first. And I think that the court's going to say, at least a majority, is going to say, or maybe all of them will say, de minimis doesn't make any sense, we're not doing that. I don't think the statutory stare decisis argument is going to carry anybody. And I think they're going to say de minimis, that's not the standard.
Except maybe Justice Kagan. But
I don't even think that she's going to go with that. And then I think they're going to offer some formulation that sounds a lot like what the SG was arguing, like substantial expense or something like that, because it's sort of like almost like the least common denominator between the two sides of the equation. But I think they will offer some examples that are somewhat helpful to us in this case and in other cases like it going forward, that give some guidance to the lower courts that make it a lot more likely that a plaintiff will get past summary judgment and have their day in court. I think it's going to take the next case to actually ratchet that down to an even stronger level and get us all the way where we should go. That would be my prediction.
Okay, good. Alan?
I don't know that I want to make a prediction as such, but I want to express a hope that, however they frame the test, that they convey the notion that this is robust protection and respect for the rights of workers to religious accommodation. And I would really like to hear something. A number of courts have said, well, these are fact questions for the jury, that they are not normally susceptible to being decided by the court on summary judgment, that they're judgment calls as to whether a hardship, undue hardship means at least, what's an inappropriate level of hardship on the company? And that's a judgment call, right? What is inappropriate under these very specific facts to ask a company to bear in order to accommodate? And, should the judge be the one deciding that in most cases, or should it be the jury that gets to decide? And if, as a practitioner, when I'm doing intake on a case and I'm evaluating whether to file a case in court, one of the things that I really want to know is, we really have a good claim to get past the summary judgment process where the other side wants the court to throw it out. We have a really good shot at getting to a jury, because then we have a much better chance of getting a case settled. And 90+% of cases settle before trial. Some lawyers insist on taking cases that they want to take to trial. We have a different approach to conflict resolution. Not every case you're going to say, we want to take it and make law with it, right? So if you really want to make law, then you're not really interested in settling. You really want to go forward. Like those who are asking Dominion not to settle with Fox. They want to see a trial, right?
Yeah, well, that you bring up kind of what I think of as just a side note. It had nothing to do with this case, but just an interesting ethical point that I don't think a lot of people talk about, which is that whenever you're doing these cases for a cause, you have to orient yourself as client first, cause second.
Mm-hmm.
Right.
You got to do what's best for your client. And so the way we always look at it is that the defendants, they choose our appellate and Supreme Court cases.
Mm-hmm.
They choose them. We're willing to settle. We're willing to be reasonable, work things out in a friendly way at any time throughout the case. We allow their obnoxiousness to decide which one goes forward.
Well, that's true. The cases we've taken to trial were because the other side wouldn't settle.
Yeah, and so this one was that this was not a settlable case. They would not be interested in settlement. Last term, our Coach Kennedy case, the school district was not interested in settling.
And the more obnoxious the opponent, the better it is before the appeals court for you typically, right? So
Makes it work out. We let them choose the Supreme Court cases.
do we have any question or two in our remaining time? We'd be happy to hear from our assembled gallery here. If anyone has a burning question, I know some
Anton?
of you listened. Okay, Anton?
So my question goes down to the test because they spent significant time trying to, delineate, okay, where we're going to come out with that test. And I've seen that both sides are focusing on the standard instead of suggesting something that is like a balancing test, ad hoc factors. At least the government was saying that there should maybe be factors that the court considered in partisan. So if we're predicting something to come out, would you want a balancing test? Would you want a set of factors that the lower court should consider, or are you putting it solely within the discretion of the lower court to just use the standard as they might fit, because at the end of the day, if that is the case, then how they view de minimis hardship can, in essence be the same thing that we see again, which is with a different standard.
Well, it can't be a balancing test with the language of undue hardship, because that is putting, first of all, it's putting the burden of proof and the burden of persuasion on the employer. So they have to climb Mount Kilimanjaro to prove their case, not the other way around. And so the best way to me that you can think of it is a accommodate unless. And so in that now the question is, how do we fill out what the unless is? But that's the framework. So it's not a balancing. It's you will accommodate unless, and then it's unless what? Unless you can prove that this is going to have some kind of real impact on your business. All right? And it can't be just something trivial or small. It's going to have to be some real or substantial. Now, the question, as Kavanaugh rightly pointed out, well, what in the world would that mean? Like, what would that look like? And the only way that I think that that's possible to articulate is to articulate common examples and have literally guideposts of common examples of situations where they would say something like if it involves premium wage, so it's really easy to come up with it. Involves premium wages, plaintiff loses. All right. Yeah. So that's part of the difficulty here. Is the easy test makes it really bad for us. Okay. So, but I think saying something to the effect of that the inverse of that, the payment of premium wages is frankly not an undue hardship. All right? Unless you can show something more than that categorically that's not an undue hardship. So I think listing some of those as categorically they're not undue hardship, they can be evidence that leads to a jury finding an undue hardship. But they're not categorically undue hardship.
So it just can't be technical violations of the collective bargaining agreement.
Right.
It has to show an actual impact on the business and the employees.
So I think they have to take a lot of off the table of what is not an undue hardship.
This whole discussion seems to me to reinforce the point that even if we have the most favorable outcome in this case, because these cases tend to be so fact-specific.
Society, not just to other Adventists or Christians, but to people of all faith.
Well, and that's right. And here's the other thing too that a new standard will change, is that right now the only financially viable way of providing representation to people in these situations is through a nonprofit model. All right. Every now and then you'll run into somebody who earns a living being a plaintiff side, worker side, Title VII lawyer. All right. And mostly they'll do the sex discrimination or the racial discrimination. Those are more obvious cases, right? In terms of proving up, but the religion cases are difficult to prove, especially right now, right? And so nobody is doing these cases for a living. And if they change the standard, it might actually become at least plausible that people in private practice could take on at least one or two of these cases every now and then. And that people of faith could have a little bit better representation. Because otherwise now, you get representation from a nonprofit, or you're on these issues, or you're not going to get representation.
Which is why Alan's practice is one of the few that actually takes these cases.
It's a church ministry, effectively,
right.
that's melded with a legal practice.
Well, I only agree with you partly on this last, because we've actually had pretty good success at least in California. Maybe California is ahead of the
Well,
curve
you do have
on
a high,
this.
you have the standard that we're seeking in
Yes.
California. So
Which-
maybe you're proving
which
his
we got
point.
enacted,
Yeah.
but, no, I mean, we've had good success at recruiting secular attorneys, employment lawyers, to assist in some of these cases. And I've consulted with a number of colleagues on religion cases. So there is a willingness to take religion cases, but that's based on California law, the courts being pretty good at protecting the attorney's fee provision. So in California, there's a presumption that if you're taking a civil rights case and you're not getting paid cash on the barrel and you win, that you not only get what your hourly fee should be, you're entitled to a fee multiplier. So recently, a close friend and colleague got a 1.75 multiplier on a case that wound up with $5 million worth of attorney's fees. It was a 7-week trial. It was a big, it's a big case. But that was not a religion case. But the federal courts generally don't give multipliers.
But it's interesting, Alan, because, I interviewed one of your clients, Teresa Brown. She told me she called 12 to 15 attorneys
15 to 20.
looking for someone who would touch her Sabbath accommodation
That's
case. And she couldn't find anyone who would touch it with a barge pole.
Right.
So there is an element to what Hiram is saying.
No, absolutely.
Yeah.
All right, we're going to finish with a lightning round, 1 minute each, down the line, starting with Bettina. What do you think is really important about this case and the principles involved, or anything else you would like to say about the case?
That's very open. I like that.
1 minute.
Well, I have split feelings on this. It's bittersweet because I'm absolutely delighted that the law in this area seems to be going the way it seems to be going. But, I don't think we should neglect the fact that, winning in the Supreme Court is hard, but we actually have a harder challenge in front of us when it comes to religious freedom. And that is clawing religious freedom back from the culture wars and restoring the reputation of religious freedom and helping people understand that it is actually a bipartisan ideal, a foundational constitutional ideal that we mess with at our peril. So while I am delighted that this case is moving the way it is, let's not think that the challenge is behind us.
We have a very small window of opportunity with the current court makeup that seems somewhat sympathetic to religious liberty, or maybe even, robustly sympathetic to religious liberty, depending on how you look at it. I don't think that majority is going to last forever. Father Time is creeping up on everybody, all the time. And so I think that the court needs to take bold steps when they have the votes to take the bold steps. And don't go through an incremental process that pours us down the river and then someday never comes because there's not a majority of justices available on that someday to finish the job.
So it really doesn't matter what the test is, what the decision is, unless it somehow provides motive and incentive for employers to take accommodation seriously. The goal of a win is not to be able to win more cases. It's that there are fewer cases because employers are accommodating. Now, one of the things that happens after a decision like this comes down is you have this huge industry of the law firms that represent the companies doing newsletters and webinars and trainings for companies, and the HR community doing trainings, and all of this stuff that, if the message will simply get out Oh, you mean now we really have to provide religious accommodation? Okay, because in my experience, if they even try seriously to take it seriously, it can be done. It's not difficult. In my discussions with potential opponents, the ACLU, Americans United, there was some agreement that in these, what the Solicitor General described as the first two buckets of many of the cases being scheduling cases and dress and appearance cases, those are easy cases to accommodate. They should almost never result in an unsuccessful effort to accommodate. You know, the rare exceptions. So my hope is that it will have an effect on the culture of our highly selfish, you know, capitalist sort of dehumanizing treatment of labor, and that workers of faith will be treated better.
Good. That's kind of where I was headed too. I think this case should cause us to reflect on the value of sacred time in our community, right? It's very interesting to me that with all the Sabbath cases we've had, this is a Sunday Sabbath keeper. And in a sense, it's kind of a canary in the coal mine. Usually it's Adventists and Jews, the minorities, that have to scrap for their days off. The post office has been closed on Sunday for a century and however long, and it's, you might call it, part of the Amazonification of American culture and enterprise.
Taking over the world.
Right, taking over the world, pressing people, pressing the spaces that used to be given to other values, family time, church time, rest time, that no, Amazon gets what it wants, and it forces even the majority, the Sunday keepers. It kind of tells you where we've come as a society in valuing capitalism and production. And as Adventists, we've had a long-term interest in this notion of sacred time. And part of that lesson is, it says that humans are more than what they produce, right? We've talked about this as the Sabbath rest. It says to the other 6 days, we're more valuable than what we just produce during the week. There's something higher and more transcendent about us. And so this is a bit of a warning that our society is spinning out of control in relation to the values of commerce and industry and capitalism, and the need to speak back these values of sacred time, of sacred place, of the transcendent, that each of us should care about and should value above these other, not that that earning a living isn't important, but we can't reduce humanity to that.
Well said.
So,
Very poetic.
thank you for attending with us this evening.
Before we close,
Jonathan
the
Scriven.
people in the audience, I think, know what. We'd just like to acknowledge our president of the university. We have Ms. Spence, who's here. Our provost was here as well. We appreciate the support that we always get from them. And Nick won't do it himself, but I want to make sure that Nick gets a lot of credit here for helping put this together. So thank you, Nick. And then I think we can all thank this panel. This has been a very interesting and
Thank you, Jonathan Scriven, who is the director here of the Center for Law and Public Policy. So thank you for spending your evening with us, and we look forward to future events that we will alert you of when they come to pass. So have a good evening, everyone.
Thank you.
thank you. Thank you guys.
Thank you.
Wow.
All right.